And welcome everyone to our legal MoT. Unlike my last MoT, at least on this occasion, you won't have to pay for 3 new tyres, so hopefully it won't be too painful. Our aim in the webinar is to run through various topics affecting businesses by way of a high-level overview to many topics which will be relevant to many businesses. We are not aiming to give a specialist analysis on in-depth matters of detail, but we're aiming to give a general overview and synopsis of the current environment for businesses as 2021 gets underway. As Bonnie said, we'll touch on the inevitable Brexit and COVID, but we're conscious that people have heard a lot of information on those topics, so we will run through those very briefly just to bring the position up to date, and following that we will focus on wider trends affecting businesses, some of which are much more positive in tone, we are very glad to see. Beginning then with fallout from Brexit and then coming on to the wider topics. The good news on the Brexit front, of course, is that the transition period finished on the 1st of January this year, and on Christmas Eve, the UK and the EU agreed the Trade and Cooperation Agreement, which has brought in force lots of regulatory alignment between UK law, which incorporates EU law as at the date at which we left the EU, and provides a basis for free trade between the UK and the EU going forward. There have, as we'll come on to discuss, been some teething troubles that many businesses, particularly in sectors such as food, have seen over the last couple of weeks, but in the longer term, the agreement, albeit not perfect in many respects, does provide a good basis for trade. The topics mentioned on this slide, we will cover very briefly, the reason being that by and large, that regulatory alignment means that most businesses won't suffer any immediate implications in terms of their contracts because of the consistency in the legal systems, which may diverge over time, but for the time being, at least are in many respects consistent. On the employment front, many businesses are finding that the settled status scheme under which EU migrant workers working in the UK can apply for long-term residency has been rolled out successfully. Like all of these big IT projects run by central government, there have been difficulties with it, but because of the long transition period and indeed the period of time since the referendum in 2016, most businesses have been able to make adequate plans. Data protection is an area, again, which is aligned. We've seen the GDPR rules with which many businesses will be very familiar over the last couple of years have now bedded in on both sides of the channel, and the data protection systems and privacy rules in the UK and the EU are substantially aligned as of today. Intellectual property is also another good area in the sense that many of the rules, in particular regarding patents and copyright, derive from international treaties as opposed to EU law specifically. So in those intellectual property areas, there haven't been material changes. In respect of trademarks, however, the position is a bit more complicated because there is a EU trademark as well as an UK trademark. The UK has automatically granted UK trademark protection to all EU trademarks, but what it means is businesses which have trademarks both in the UK and in the EU are now able to treat those two separate IP trademarks distinctly. So in other words, trademarks can be licensed or assigned in the UK, but don't simultaneously have to be treated in the same fashion in the EU and vice versa. So those trademarks are now best regarded as being two separate trademarks in two separate geographical areas. Again, the underlying system of registration and ongoing maintenance of filings and so on will now be dealt with under two systems. So over time, there is scope for divergence, but currently those two systems are substantially similar. In terms of disputes, again, there are wider rules not linked to the EU specifically, under which countries recognise court judgments and enforce them in their own territories. So an English law judgment should be enforced in Germany, for example, and vice versa. And the international law principles around those aspects of law are substantially unaffected by Brexit. It's always worth, if you are going to embark on a major commercial dispute, checking your immediate position. But by and large, we find so far, at least, that companies haven't experienced difficulties enforcing their agreements in countries within the EU. The bad news, of course, you will all have seen, is in relation to the export and import aspects. The need for customs declarations, proof of origin certificates, and certifications, especially in relation to products such as foodstuffs and dairy, others also medicines, has been producing lots of administrative and bureaucratic work for importers and exporters. The UK is frankly going to need many more customs agents and freight forwarders to help businesses navigate the new systems, and that will hopefully enable them to adjust over time. Northern Ireland, we must apologise to Northern Ireland because we won't cover this in any great depth, given that it's a very small market, but Northern Ireland is an important jurisdiction, and the separate regime under which Northern Ireland is in effect a continuing member of the EU single market, whilst being for customs and constitutional purposes part of the UK, is likely to create ongoing obstacles. The Northern Ireland Protocol between the UK and the EU should help businesses facilitate the resolution to them, and a joint committee has been established to try to find cooperation and to facilitate progress on some of the practical issues that will inevitably arise in relation to the border between Northern Ireland and the Republic. Despite the saying Brexit is done, as per the Prime Minister, there are, as you'll appreciate, further steps to be experienced in the future. At the end of March, the grace period for the moving of agri-food products into Northern Ireland for authorised traders such as the big supermarkets will expire, and therefore some of the checks and friction at the Northern Ireland sea border now between Great Britain and Northern Ireland may become more acute. From July, the UK will be applying some of these export and import requirements to exports from the EU into the UK. Currently, the UK has decided on a unilateral basis not to apply those checks, but they will come in from July. So some of these scenes we've seen in Dover, for instance, with confiscation of ham sandwiches and so on from drivers, we will see parallel checks on movements of products into the UK from the EU. In some ways, that may facilitate progress, because when each side is affected, we will then perhaps incentivize them to make sure that there's a practical solution to some of these technical issues at the border. In the middle of the decade, the whole agreement will be up for review, and although it sounds like a long time away, no doubt it will soon come. And fishing, as we've seen, has been a very sensitive area for political reasons, disproportionate to its commercial impact, and that too will be an ongoing issue. So Brexit is not quite done, but as we've seen so far, at any rate, most of the news is broadly positive. On the COVID front, of course, we see daily headlines on the unfolding tragedy of COVID, and we've seen the milestone this week of 100,000 COVID-related deaths. Many businesses have been struggling with the practical implications of it for the best part of a year, and we won't go over the history of it. But a fortnight or so ago, there was a case in the Supreme Court which will hopefully be of use to the best part of 400,000 SMEs in the UK, enabling them potentially to recover insurance payouts of an estimated £1 billion. The FCA brought a test case to the Supreme Court, under which the Supreme Court analysed policy wording in 8 standard form insurance contracts. So not every policyholder, of course, will have exactly the same form of words in their particular policy, but they were taken as a representative sample. The insurers tried to defend liability in respect of disease clauses, under which the insured could recover compensation for losses resulting from a notifiable disease, by arguing that COVID was a wholly new disease. The virus hadn't been known about at the time at which the policy was taken out, and the insurers argued that therefore it was excluded from the coverage under the policy. The Supreme Court held that no, the insurer's argument failed, and that the policyholders could indeed recover losses attributable to COVID because it was of a type of disease that the category related to. So we have seen over recent years epidemics such as SARS, avian flu, and so on. And the court said that COVID-19 was a continuation of those species of illnesses which were covered. In respect of prevention of access clauses, under which businesses can be compensated for losses where public authority intervention means that they have to close, the court said that those clauses did apply, and therefore the policyholders could recover under them. The insurers had argued that in the case, for instance, of a restaurant which would be unable to provide dining in facilities, but might be able to continue its business through a takeaway offering, the insurers would say that because the businesses can carry on providing takeaway facilities, they haven't been completely closed down. The Supreme Court held that, again, the insurer's argument failed, and that where a business such as a restaurant did have to close down a substantial part of its operation, the clause did apply, even if the closure wasn't total in respect of all of its business activities. The insurers also argued that televised speeches by the Prime Minister instructing people to stay at home did not constitute public authority intervention because it was not based on a legislative footing. Of course, retrospectively, many of the regulations were put into statutory form. However, the court said that even the instructions from the Prime Minister were sufficient to amount to public authority intervention, and that there was no loophole under which the insurers could deny liability. So hopefully that case in the last fortnight will come to the aid of many smaller businesses, and they will be able to find that they can get compensated and hopefully tide themselves over until more normal trading conditions resume. Many businesses will have experienced much inconvenience, to say the least, in relation to their employment situation. Many workers, of course, have been able successfully to work from home, but that hasn't saved all businesses, and there have been ongoing difficulties. In particular, as the pandemic has extended, the application of normal disciplinary processes within the workforce has been quite difficult to maintain, trying to be fair to employees who are not in their normal work environment, but at the same time trying to make sure that people are, as it were, pulling their weight and not creating difficulties for other colleagues working remotely. Systems of holiday entitlement, and now the ability for most employees to carry forward holiday for 2 years has seen adjustments to systems there. Mental health support and the duty of care employees owe their staff, again, is an ongoing requirement for them to monitor their systems and update them. remote working in the longer run could create tax obstacles if some employees, particularly senior members of staff, may be seen as having a tax residence in a different jurisdiction from the host country of the employer. So where, for instance, employees are working from second homes or from family members' homes, then there would be a need to ensure that there are no tax-related issues from that. And of course, as businesses look to transition from lockdown, many staff find working from home to be quite a comfortable arrangement for them, and they will be reluctant to come back. However, in the longer run, both for the good of individual businesses and more widely for city centres and related economic activity, I think we will need to see a return to normality. And although many businesses will phase this in, the practical obstacles and logistical obstacles about ensuring COVID secure workplaces and treating employees well as that programme of returning to work is managed will become increasingly pressing. From a corporate perspective, we've seen a substantial decrease of merger and acquisition activity since the beginning of the outbreak of COVID-19. As a rule of thumb, probably activity has been about a third of its prior levels. Some of it has been distressed M&A, where businesses have failed and been taken over by competitors in the pandemic. Some people have had to do transactions as a result of their normal exit planning considerations. We've seen that payments for businesses has been increasingly structured so that by way of deferred elements and earnouts, what a buyer pays for a target company will be adjusted over time and reflect the performance of the business in this post-pandemic era, and therefore they won't have to nail their sales to the mast up front by paying that fixed price. So some of those adjustments have fed through into the M&A process. Funding for transactions has been quite difficult for many companies to obtain. Many of the banks have been very preoccupied with the CBILS Corona loan scheme, and some of them haven't had the bandwidth to provide the normal relationship support for commercial loans, but that may come back as the pandemic eases. We've seen in particular sectors such as leisure, hospitality and retail, company voluntary arrangements and restructurings to try to put their businesses on a more sustainable footing. Landlords generally have been sympathetic to the position in which these businesses find themselves, but those fixed costs, leases and rental costs will be an ongoing issue. Oddly, despite some self-employed groups being outside the support net that the government has established, we are seeing an increase in startup activity. And just today, the Royal Bank of Scotland has announced a £1 billion programme aimed in particular at female entrepreneurs. And they estimate that that programme will support 35,000 startups in the UK over the course of 2021. So many people and entrepreneurs have found that they've had the opportunity enforced on them by COVID to reconsider their future business prospects, and they have taken the opportunity to focus on a niche startup project. So we are seeing, despite the general pessimism, some applications of initiative and new businesses starting. So let's hope that's a good trend and a continuing one as we continue to emerge from the pandemic and the vaccine rollout carries on at pace. Turning then to broader topics, all businesses will be finding that the advent of social and human rights and environmental legislation carries on at pace. The government has set extremely stringent targets to reduce carbon emissions by 68% by the end of the decade, and also phase out petrol and diesel vehicles, bringing in electric vehicles and rolling out national infrastructure for charging points. The climate change conference at the end of the year in Scotland is likely to result in more stringent environmental conditions. And of course, all of these national targets will feed down into obligations imposed on businesses, on families, on consumers. So this trend can only accelerate as the focus and political discussion around climate change issues and the approach taken to them by the new incoming Biden administration rejoining the Paris Climate Accords will all go very much in one direction. As well as the environmental factors, broader human rights related considerations are also topical. About a week or two ago in the House of Commons, a vote to ensure that the UK could only trade with countries which did not have incidents of genocide failed by just 11 votes. The government took the line that arguments about genocide are fundamentally political and criminal and should be pursued through appropriate mechanisms such as sanctions via the United Nations or criminal prosecutions at the International Criminal Court in The Hague. And the government was mindful that if there were an argument that countries which were accused of genocide might be outside the net for trading agreement purposes, that could lead to potentially politically sensitive arguments being raised in a number of countries across the globe, raising difficult issues as to what exactly does constitute a genocide. How do you treat a country if a government has been replaced and the outgoing government may have perpetrated genocidal acts, but that responsibility doesn't attach to the incoming government? So that debate might come back in some shape or form because there will be a lot of pressure. And if ultimately a provision along those lines does become law, that will impact on the UK's ability to enter into free trade agreements following Brexit. And it may be that future trends will be to extend that not just to issues such as genocide, but wider issues such as environmental damage, child labour, and others. Returning to the UK, the Supreme Court in the week before Christmas has given permission for the Heathrow Terminal 3 application to continue. So that third runway hasn't yet obtained permission, but the court has held that the process can go forward. There had been a breach, allegedly, of the UK's climate change targets, which would mean that many people would suffer from air pollution, and various pressure groups brought the claim, arguing that the UK government would be infringing international agreements, and therefore the Heathrow third terminal had to be changed. The Supreme Court found that no, the Heathrow project could continue on the basis that even though these stringent targets had been agreed, the targets that were in place at the time the process began were the relevant ones for these purposes. However, there will now be very likely a challenge to the airport's plans at the European Court of Human Rights, which hasn't been affected by Brexit. The European Convention on Human Rights has a separate international framework, and the claim that the airport and the pollution a third runway would cause might infringe people's right to health, right to clean air, is likely to be raised again at the European level. There's a challenge on very similar grounds to the UK's road building programme, and on yesterday's news you will have seen the environmental activists digging tunnels underneath Euston Station in London, trying to block the development of the HS project on high-speed rail. So all of these major infrastructure projects, whether air, roads or rail, are being consistently attacked by environmental pressure groups, and the climate around them is becoming increasingly sensitive. On the international plane, Dutch courts have held that the Netherlands government has a legal duty to protect citizens from climate change, and that obligation will indirectly impact upon businesses which cause pollution or other environmental damages. The direction of traffic isn't completely one way. We've seen in Norway that a court challenge to block licenses for oil exploration in the Arctic territories has failed. The court said that those licenses were valid and the oil exploration and drilling could continue. The court said that ultimately it was a political question, not one for the courts to resolve as a legal matter. But Norway, in that particular case, is probably something of an outlier. And certainly we see the general direction of travel very much in favour of upholding environmental rights and upholding challenges. More broadly, in the last fortnight, a case has been launched against Biffa, the waste management firm, in relation to modern slavery and trafficking allegations. This case concerns 3 migrant workers from Poland whom Biffa recruited via an employment agency. And it's alleged that human traffickers had control of the bank account into which their salaries were paid, and that the employees only received payment of approximately £5 per week per employee, and were living in substandard accommodation organised by, in effect, gangmasters. Biffa, we should say, denies liability and says it did undertake the necessary checks to ensure that the employment status of these individuals was appropriate. But those issues around child labour, around traffic labour, slave labour, and in other cases child labour, will become increasingly prevalent. Also, we saw towards the tail end of last year allegations that Boohoo in its supply chain had been undertaking very bad practices in plants around Leicester and other places where employees may not have been paid properly and had very poor living conditions and working conditions too. So the responsibility both for big organizations to manage their own employees and workers and also monitor their supply chains will become increasingly important, and a big area for campaigning groups to facilitate some of these legal challenges. Going through Parliament at the minute is the Domestic Abuse Bill, which has various dimensions to it, but from an employment perspective, the atmosphere around employees needing to make allowances for employees who are subject to domestic abuse and to make reasonable adjustments for them is likely to be increasingly sensitive as time goes on. Of course, many British people will have a natural reluctance to inquire into people's domestic arrangements, but we've all become familiar over the last few months with Zoom arrangements and seeing inside people's homes, and where an employer is told or becomes aware of domestic abuse concerns in respect of employees, it might be that they would need to take steps, for instance, to ensure that salaries are paid into the right bank account. In other words, make sure that the employee has control over the funds and that they're not paid into an account which may be controlled by, for example, an abusing husband. It may also be the case that more flexible working patterns or emergency time off may need to be increasingly given to employees who find themselves in a situation of domestic abuse. So some of these areas which previously we would have thought of being very much a private or family matter, not affecting an employment relationship, are coming into the domain of the employment angle. And many HR departments will be monitoring closely this bill as it passes through Parliament. Monitoring employees working from home, both during COVID and as those patterns of work increasingly become prevalent in the post-pandemic era, will again be a sensitive area. Many employees don't like some of the IT-related tools employers can use to check on their daily habits and their productivity at home, and striking that balance is very difficult for many employers. The anti-bullying agenda within the workplace again has become a very sensitive area, and some of the issues we see around the Me Too campaigns, wider bullying campaigns, whether it's shouting and as for instance, the Home Secretary was accused of by her civil servants, shouting and being belittling to staff, allegations which she denies. But over time, there's a ratchet effect where behaviours and activities which previously may have been thought of as being robust management are increasingly now being seen as tipping over into harassment and bullying, and that dividing line is becoming more difficult for HR departments to manage. Future trends more widely, especially for businesses with an online presence, will be the online harms white paper, which is expected to feed into legislation to try to curtail online harms such as exposure to self-harm material to vulnerable people, as well as extremist content and criminal content, whether that's terrorist or money laundering related or any other criminal activity online, including financial fraud and phishing scams and so on. So the balance in terms of whether these online companies are, for instance, publishers or platforms, the extent to which they have to take responsibility and can be held liable, whether under civil or criminal law, for the content placed on their platforms is becoming an increasingly hot topic. There is a discussion in the white paper as to the appropriate balance of liability between the company itself and its senior directors and managers, and in particular, whether personal liability can attach to particular individuals as a result of their executive responsibility within the business. The feeling amongst many campaigners is that in order really to hold people's feet to the fire, this threat of personal liability for senior managers and the reputational harm they will sustain in terms of their own business careers is needed to really focus minds, and that merely financial disincentives on the companies themselves, such as fines, will not be sufficient to rein in some of this improper activity online, because the scale and size of some of these huge companies is such that fines may represent a mere pinprick to them and not represent adequate punishment. The UK Competition and Markets Authority has blocked a proposed transaction in the ticket buying arena via GoGo, saying that if it were to buy StubHub, it would have too dominant a position in the market, and that was blocked. So some of these concerns around the dominant position exercised by some of the big tech companies may impede their M&A activities, and also may also lead to the potential need to break up or divest themselves of part of their business. And we see a case against Facebook by the American government trying to make Facebook divest Instagram and WhatsApp on the basis that having all of those facilities under one roof is too big a concentration of power in Facebook's hands. In Australia, the national government is in a dispute with Google under proposals to legislate in Canberra to make Google responsible for paying news organisations for the use of journalistic content on its platforms and via its search engines. Google has threatened to pull out of Australia completely, and that's a reflection of the respective balance of bargaining strength between the tech conglomerates on the one hand and national sovereign governments on the other. And it may be that some of these companies are now so large that they can only really be addressed in terms of some of their practices through concerted action at an international level, as opposed to by one country acting alone. Justin Ellis of this parish delivered a webinar towards the tail end of last year on artificial intelligence, and I heartily recommend that to you, and it's available on our website and on our YouTube channel. So I won't rehearse any of his discussion around artificial intelligence and robotics, save to note that there was a report by the government's independent advisors just this month, the AI Council, recommending that the UK adopt a 10-year programme to build a national strategy on AI and to boost skills and to give greater public confidence in AI decision making. Now, of course, that confidence has probably had a knock in the pandemic, where we've seen, for instance, the use of algorithms to grade exam results being rejected and resulting in lots of confusion in the examination system. But more widely, as these technologies become more prevalent, there will be scope for them to become increasingly accepted. Robotics and autonomous systems more generally, and how they intersect with AI, is likewise part of this broader agenda. And as we become more used in years ahead to self-driving vehicles, especially as part of the environmental revolution and away from the internal combustion engine, we will become increasingly used to seeing robots, whether it's logistics, whether it's in the farming context, whether it's electric vehicles, being used more widely for commercial application. The government has funded a pilot scheme in the north of England called the Made Smarter initiative, whereby it's encouraging SMEs in the manufacturing sector to exploit digital technologies. And the aim is to facilitate projects by entrepreneurs and SMEs to exploit robotics, AI technology, and also drone innovation. The Civil Aviation Authority launched its Innovation Gateway before COVID, and it's largely, I think, been on ice since then. But again, the use of drones, robots, other AI technology will continue apace only in one direction as the years pass by. And some of these new reviews, including the AI Council review just this month, will feed into increased government expenditure on some of these pilot schemes in order to encourage further growth in this important area, where the UK has a very substantial track record already, and the UK government is very keen that we continue to build on that initiative. So I suspect the UK government's funding of these initiatives will substantially need to increase in the years ahead, but we are moving forward very well as a country, and AI, robotics and drones will hopefully be a growth area for many businesses in the coming years. So the landscape then is, let's hope, as we emerge from the pandemic positive, many businesses will be trying to return to some sort of normality as the vaccine rollout continues apace. They will then continue to grapple with the wider trends, in particular on environmental pollution, human rights, the social and CSR agendas, which at one point were regarded almost as nice to haves or optional extras. But as we've seen, the increasing tendency for legislation to be imposed, making these requirements, particularly for tech businesses and online businesses, to be responsible for some of these wider social harms, is increasing the legal onus on companies and, in some cases, their senior managers and directors at a personal level. So this is a flavour of some of the trends and patterns we are seeing as legislation catches up with some of the emerging technologies. And these are very much topics for businesses to have on their radar in the time ahead. That brings us to the end of our prepared remarks. And perhaps, Bonnie, I can now hand over to you to run through any Q&As which guests may have sent in over the course of the webinar.
Thank you, Tony. And yes, we'll now move on to the Q&A section. So if you're interested in participating, do use the Q&A button to submit your questions, and Tony will try to answer them live for you. And as I can see, I think there are 2 questions during the webinar, and I'll go on the first question, which is, hi, Tony. Many of my staff prefer working from home, but after the lockdown ends, I want to get people back in the office. Can I make them come back, or is it really a case of trying to persuade them? Tony, would you like to take this?
Yes, it's a very difficult area, really, and I think it will depend on the business concerned and also the level of employees. We should, of course, all have some humility. Many of us have been able to work from home and to rig ourselves up in the spare bedroom and work quite effectively. We should, of course, be conscious, though, that millions of workers haven't had that privilege, whether they're workers in frontline emergency services, on the transport network, in our shops and supermarkets. Many people have had to work throughout this pandemic and expose themselves to personal risk. And therefore, some employees who think, oh, well, I've in fact had a relatively nice time through saving myself the stress of commuting, being able to work from home. It may facilitate my childcare arrangements. It's more convenient. And now I've got used to it. I, in fact, don't wish to go back to the old 9 to 5 commuting into the office routine. However, I think we should be conscious that the inability of many businesses to work in a normal pattern has had a substantial knock-on effect for other businesses, shops, and so on in city centres. And I think for wider economic reasons, we will be keen in many instances to get businesses back to normal. Businesses will, of course, have to be sensitive, in particular for employees with medical conditions, people who have vulnerabilities. But in general, an employment contract will give the employer the ability to require employees to come back into the workplace. However, I suspect that the questioner is right in terms of persuasion, that many businesses will be phasing it in, perhaps coming back to work on a part-time basis initially, so that it becomes a gentle and flexible process, trying to take the staff's goodwill with them as they, over time, gradually get back to more normal work patterns.
Perfect. And we have another question from an anonymous attendee. Another COVID-related question, which is the court case about COVID triggering insurance payouts will help many small businesses, but will the insurance companies just be able to change their policy wording to avoid paying out if anything similar happens again?
Well, I'm sure the insurance companies and their lawyers are already working hard at trying to make sure that if, heaven forbid, there is a future pandemic, that the insurance companies won't be obliged to make payouts. The difficulty here, of course, is the balancing act, because although it's tempting to say that the insurers should always have to pay out, equally we have to be mindful that that presents a great burden on insurance companies. And if those insurance companies are pushed into insolvency, ultimately that won't benefit SMEs and people needing to take out policies. So trying to get that right balance between a good level of protection for businesses, but at the same time not unduly stretching the insurance companies, is a difficult one. It may be that at a government level, a crisis such as a global pandemic may need to be looked at along the lines of the financial crash of 2008 to 2009, where just as the banks were propped up to some degree by state intervention, a pandemic type scenario which could destroy insurance companies might be a ground on which national governments might need to give some financial support to make sure that those insurance companies are able to carry on in operation. So it will be a difficult balancing act, but even if the insurance companies tried to change their wording to exclude liability for future pandemics, in some ways, businesses will at least have clarity as to what is or is not covered. Whereas the difficulty with the COVID case that was just before the Supreme Court was the ambiguity and the unclear position of the law. So at least that legal position having been clarified in the test case will mean that businesses know where they stand, and it may be they'll have a choice between paying a higher premium for better cover or taking the risk of paying a lower premium and having the insurance company exclude the liability, but at least they'll be able to reach that as an informed decision, as opposed to paying the premium and then just keeping their fingers crossed that the policy will actually work if, as we say, heaven forbid, some other COVID-type disaster were to materialize in the future.
Great. Thank you, Tony. And as I haven't seen any other questions on the Q&A section, I think this is the end of our webinar. And thank you, Tony, and thank you everyone else for participating in the webinar. If you have any more questions or corporate issues that your company is facing and you would like to discuss with Tony, you can email him directly, and the email addresses can be found on the agenda and also our brand new website. We'll be sending out the PowerPoint slides and the feedback form to you shortly, and it will be great if you can just spend 2 minutes of your time to fill it in so we can make these webinars for you. If you would like to rewatch this webinar or send it to your colleagues or to share them, this webinar will be made available on YouTube on demand shortly. So make sure you follow us on LinkedIn to get updates about it, and also to get updates about our future webinar invitations. Thank you so much for participating, and we hope to see you again in the next webinar. Thank you.
Thanks, everyone. Thank you.
Bye.